Welcome to the Arbitration World podcast, in which we focus on significant developments and issues impacting international arbitration. We hope you enjoy this discussion. Please do get in touch with us if you have any questions about this week's episode or any areas you would like us to cover in a future podcast in this series.
Welcome everyone to this latest podcast in our Arbitration World podcast series. Today we're going to be covering practical implications of recent English decisions on the governing law of an agreement to arbitrate. My name is Peter Morton. I'm a partner in the London office of K&L Gates and one of the practice group coordinators of our international arbitration group. I'm joined by Tim Fox, special counsel in our London office and also a member of the firm's international arbitration practice group. Tim has authored a number of articles on the line of cases that we will be discussing regarding the law governing an agreement to arbitrate. And in this podcast, after a refresher on the relevant issues and a summary of what those cases decided, we're going to look at some of the practical implications, in particular for those who may be drafting an arbitration clause in a cross-border contract. Now, before we get started, we just need to state that this podcast series is limited in scope by reason of applicable time constraints and has been prepared on a basis appropriate for a general audience. The information in the podcast series is not offered as legal advice, which should be obtained only from properly licensed legal professionals on the basis of the specific facts of a given case. And finally, all speakers appear in their personal capacities, and any opinions or views offered are those of the relevant speaker alone and do not necessarily reflect the opinions or views of K&L Gates LP or any other entity or individual. So with that, Tim, just to kick things off by way of background, when you have a contract that contains an arbitration clause, what are the relevant governing laws that need to be considered?
Thanks, Peter, for that introduction. There are potentially up to three governing laws, the first being the substantive law of the contract itself, and that will be the law that regulates the rights and obligations of the parties. The second and the third relate to the agreement to arbitrate, which will be contained within the contract. But under this notion of separability, the agreement to arbitrate is often considered to be a separate agreement, albeit falling within the same document. So within that agreement to arbitrate, you can have the parties choosing the law of the seat, which in effect is the law of the country whose courts will end up supervising the arbitration. And finally, the governing law of that arbitration agreement. And this is important because the choice of law, whether it's express or implied, of the agreement to arbitrate may have an impact on later satellite litigation or any disputes as to the validity of the agreement to arbitrate, including questions of jurisdiction of the tribunal and or enforcement of any award made by the tribunal.
Okay, well, that's helpful by way of context. So what has been the approach of the English courts, at least, to ascertaining the law of the arbitration agreement?
Well, until relatively recently, the law on this was that set out by the Court of Appeal in 2012 in the case of Sul America. And in the Sul America case, the court laid out a three-stage test for determining the governing law. First of all, you look at the party's express choice. If there is no express choice, you look at whether there is an implied choice, and that second limb blurs into the third limb, which is sometimes referred to as the closest and most real connection test. In other words, with which country's law does the agreement to arbitrate have its closest connection? Now, in the Sul America case, the court found that the default position of the implied choice of the law of the arbitration agreement will be that it will be the same as the law of the seat of the arbitration. And in that case, English law was the law of the seat, so English law governs the agreement to arbitrate. And that was a case in which other factors in the factual matrix pointed to Brazilian law as the governing law of the agreement to arbitrate. But under Brazilian law, the agreement to arbitrate may have been undermined. So there was a pragmatic decision there to uphold the validity of the arbitration agreement. And that's consistent with the notion of separability that I referred to earlier on, this idea that the agreement to arbitrate is a separate contract, and it's consistent with cases decided prior to it. But then the Supreme Court, a few years later in 2020, changed this position. This is the case of Enker against Chubb, decided in October, or handed down in October 2020. This was a case arising out of a fire which had caused damage to a power plant. Chubb, Russia, had commenced proceedings against Enka in the courts of Moscow, and the relevant agreement contained a London-seated arbitration agreement. Now, Enka sought to restrain the court proceedings in Moscow by asking the English court for an anti-suit injunction, and the Supreme Court ended up upholding the injunction. The Supreme Court found that the second limb of Sul America, the implied choice of the governing law, would generally be the law of the substantive law of the agreement rather than the law of the seat. So it reversed the position in Sul America. But that inference that it will generally be that the law governing the arbitration agreement will generally be the same as the substantive law of the main contract can be defeated if that choice of governing law would render the agreement to arbitrate ineffective. So it's not a hard and fast rule.
That's position as at October 2020 with the decision in Enka and Chubb. I understand there's been a further chapter in this developing story, a decision in October 2021 on the topic from the UK Supreme Court. So what was that case and what does it tell us beyond what Enka decided?
Yes, that's right. The case to which you're referring is called Kebabji against KFG, which was handed down in October 2021. And what it does, it extends the principle in Enka and Chubb to the enforcement context. Kebabji concerns a franchise development agreement that was governed by English law. But the agreement also contained an arbitration agreement providing for arbitration seated in Paris. Now, KFG, which was the respondent to that arbitration, which had become the parent of the original signatory to the arbitration agreement following a corporate reorganization, argued that it was not a party to either the franchise development agreement or the agreement to arbitrate. But nevertheless, the arbitrators in Paris made an award in favor of the claimant Kebabji, and they decided that French law, being the law of the seat, is the applicable law determining whether or not KFG was bound by the agreement to arbitrate. And under French law, the tribunal found that notwithstanding the fact that it wasn't an original signatory to the arbitration agreement, it became a party through its conduct, and the tribunal awarded damages against KFG totaling around $6.7 million. After that, the claimant Kebabji brought proceedings in the English Commercial Court to recognise and enforce the award that they'd obtained. And what the English Supreme Court found was that they extended the principle in Enka and Chubb to the enforcement context. They found that the language in the substantive agreement saying that the agreement will be governed by the laws of England was sufficient to denote all the clauses in the contract, including the agreement to arbitrate. So they found against Kebabji, and they upheld the decision of the Court of Appeal in England that they were not allowed to get the award recognised and enforced in England because KFG was not under English law a party. The other argument that Kebabji sought to rely on is known as the validation principle. And this is the principle according to which contractual provisions, including any choice of law provision, should be interpreted so as to give effect to the validity of the agreement to arbitrate. And the court found that that was an attempt to extend the validation principle beyond its proper scope. The court found that the validation principle could not be invoked essentially to generate an agreement which would not have otherwise existed.
Okay, thanks, Tim. So just stepping back and perhaps most importantly, what are the key practical takeaways arising from these cases?
Well, as you can probably tell from my discussion of Kebabji, this is contentious at an international level. The tribunal in Paris, of course, found that notwithstanding KFG not being an original signatory to the agreement to arbitrate, nevertheless, it was bound by it. And that's the opposite approach that the English Supreme Court took in its decision under English law that KFG was not a party to the agreement to arbitrate. So you can see the potential for expensive and time-consuming satellite litigation on these issues. And the way to short-circuit that and to avoid the possibility of expensive litigation is simply to specify the governing law of the agreement to arbitrate in your arbitration agreement, particularly where the governing law of the main agreement differs from the law of the seat of the arbitration.
Great, thank you, Tim. Just before closing, I should mention that the articles to which I referred on this topic, authored by Tim, are all available on the Thought Leadership section of the International Arbitration Practice Group page on our firm's website, which is www.klgates.com. So it just remains to say thank you very much, Tim, and thank you everyone for joining us. Goodbye for now.
Thank you for listening to this episode of Arbitration World Podcast. To listen to past episodes and receive notices for new episodes, subscribe by searching Hub Talks, that's HUB Talks, in your favorite podcast app. We hope you will join us next time for further discussions on hot topics and significant developments in international arbitration from around the globe.